Welcome back to Artificially Informed, the podcast series that offers an in-depth look at the Florida Attorney General's Government in the Sunshine Manual, 2025 edition. I'm Joel Chandler, and as always, this episode is produced with the extensive use of artificial intelligence. I write the prompts and review and edit all of the output. In today's episode 16, we're continuing our in-depth exploration of Part 2, Public Records, specifically see what records are covered. Application of the Public Records, Act 2. We'll be navigating pages 127 through 139 of your manual. Our discussion will cover litigation records, personal records not made or received in the course of official business, and the beginning of personnel records, including topics like annuity and application records, collective bargaining, and complaints against employees. Let's jump right into the nuanced world of records related to legal disputes. Segment 1. C. What records are covered? Litigation records. Attorney-client and attorney work product. Pages 127 through 132. Starting on page 127, we begin with 16. Litigation records. These are records that come up when public agencies are involved in lawsuits. This area involves a couple of important legal privileges that can make certain records confidential: attorney-client communications and attorney work product. First, A. Attorney-client communications 16A on page 127. Just like in the private sector, communications between a public agency, its board members, officials, or employees, and its attorney are generally protected by attorney-client privilege. This means these conversations and records are confidential. The idea is to allow the agency to get full and frank legal advice without worrying that every detail of their discussion will become public, which would make it hard for them to effectively get legal counsel. This privilege is generally quite strong. Next, on page 127, we have B, Attorney Work Product 16.B. This privilege protects documents and materials prepared by an attorney or prepared at the attorney's direction in anticipation of litigation. It shields the attorney's thoughts, mental impressions, legal theories, and strategies from the opposing side. Let's dive into the specifics of attorney work product. 1. Scope of exemption, 16.B.1, on page 128. This explains what exactly is covered by the work product exemption. It's meant to protect the preparation of a case for trial. This includes A. Attorney bills and payments, 16.B.1.A, on page 128. While the general public has a right to know how much public money is spent on legal services, details in attorney bills that would reveal confidential attorney-client communications or trial strategy are generally confidential, the total amount paid might be public, but the granular details of work performed, if it reveals strategy, could be exempt. Then, on page 129, we discuss B. Records prepared prior to litigation or for other purposes, 16B.1. B. This is a key distinction. For something to be attorney work product, it generally has to be prepared in anticipation of litigation. If a record was created for some other purpose, like routine administrative work or general policy review, it's probably public even if it later becomes relevant to a lawsuit. The intent behind its creation matters. The courts distinguish between records prepared for general business operations and those prepared specifically because a lawsuit is expected. Moving to page 130, we cover C, settlement records, 16.B.1.C. Records related to settlement negotiations, like settlement offers or counteroffers, are typically confidential as attorney work product while the negotiations are ongoing. This encourages parties to settle without fear of their negotiation positions being publicly revealed. However, once a settlement agreement is finalized and approved by a public body, the final agreement itself typically becomes a public record unless a specific statutory exemption, like the Sunshine and Litigation Act, Section 69.081, Florida statutes, which we covered in Episode 10, dictates otherwise, especially if it involves public hazards. Finally, on page 131, we have 2. Duration of exemption, 16.b.2. The attorney work product exemption isn't forever. It generally lasts as long as the litigation for which it was prepared remains active or pending. Once the litigation is completely concluded, including any appeals, the work product generally loses its confidential status and becomes a public record. The idea is that once the strategy is no longer relevant for the current case, the public's right to access outweighs the need for confidentiality. Next, on page 132, we discuss the C, other statutory exemptions relating to litigation records, 16D. Beyond the general attorney-client and work product privileges, sometimes specific statutes create additional confidentiality for certain types of records that might arise in litigation. These are usually highly specialized and apply to very particular kinds of information, further underscoring that exemptions must be explicit in law. Also on page 132, we have D, attorney notes, 16.d. Attorney notes, particularly those made during depositions, witness interviews, or strategic planning, often fall under the attorney work product privilege. They reflect the attorney's mental impressions and trial strategy, making them confidential. However, this is distinct from notes that might be records themselves if they formalize or perpetuate information for agency business beyond just litigation preparation. Segment 2, C, what records are covered by personal records not made or received in official business, page 133. Now let's shift to page 133 and discuss a very important distinction. 17. Personal records not made or received in the course of official business. This section clarifies that not every piece of paper or digital communication generated by a public employee or official is a public record. The key phrase here is in connection with the transaction of official business. If a record is purely personal and has absolutely no relation to official agency duties or public business, then it is generally not a public record under Chapter 119. For example, a personal shopping list written on a notepad in a government office, an email from a public employee to their spouse about weekend plans sent from their government email account if it genuinely contains no public business content, a private photograph stored on a government device if it was not made or received in connection with official business. The challenge, of course, is drawing that line. If a record contains any mix of personal and public business content, or if a personal communication is made or received in connection with official business, like a text message about a public meeting, even if sent from a personal phone, then it is generally considered a public record. The personal portions might be redacted, but the public business portions would be accessible. The burden is on the agency to prove that a record is purely personal and not related to official business to withhold it entirely. The guiding principle is to avoid using public resources for private purposes that then get shielded from public view. Segment 3, C, what records are covered, personnel records, intro, annuity, applications, and collective bargaining, pages 135 to 136. Moving to page 135, we begin a very extensive and often requested category. 18. Personnel records. These are records related to public employees. While a lot of personnel information is public, certain parts are confidential to protect employee privacy. Let's start with some general categories. First, on page 135, we have A, annuity or custodial account activities, 18A. This refers to records related to an employee's personal investments or retirement savings accounts, specifically annuities or custodial accounts. These types of financial records are generally considered confidential and exempt from public disclosure. This protects the employee's personal financial privacy, as these are individual investment decisions. Next, still on page 135, we have B, applications for employment, references, and resumes, 18.b. When someone applies for a job with a public agency, their application materials, including resumes, cover letters, and references, are often kept confidential during the active hiring process. This confidentiality helps to attract a broader pool of applicants who might not want their current employment status known. However, once the hiring process is concluded, e.g., a person is hired, or the selection process is terminated, some of this information, especially about the finalists or the successful candidate, may become public. References, however, often remain confidential to encourage candid feedback. Finally, for this segment, on page 136, we cover C, collective bargaining, 18.c. This refers to records related to negotiations between public employers and employee unions. 1. Relationship of collective bargaining agreement to personnel records, 18.c.1 on page 136. The final collective bargaining agreement itself, once approved, is a public record. However, some individual employee information within those agreements might be confidential if it falls under other personnel exemptions. 2. Collective bargaining work product exemption, 18.c.2, also on page 136. Just like attorney work product, there's an exemption for the work product developed by the public employer in preparation for negotiations and during negotiations. This is found in Section 447.605, subsection 3, Florida statutes. This exemption ensures that the public employer can develop its bargaining strategy without that strategy being immediately known to the employee union. This allows for effective negotiation. However, this exemption is generally limited to the preparatory materials and does not apply to the actual bargaining sessions, which are subject to the Sunshine Law, as discussed in Episode 6. Segment 4, C, what records are covered. Personnel records, complaints against employees, law enforcement, correctional, pages 136 to 139. Continuing our discussion of personnel records, we move to page 136 to discuss D, complaints against employees, 18.d. This is a particularly sensitive area, especially concerning law enforcement and correctional officers. Let's break down the rules for 1. Law enforcement and correctional officers, 18.1, starting on page 137. Records related to complaints and investigations of misconduct against police officers and correctional officers have specific temporary confidentiality. A. Scope of exemption and duration of confidentiality, 18.d.1.a on page 137. The identity of a law enforcement or correctional officer who is the subject of a complaint alleging misconduct, and any information that could reveal that officer's identity is confidential and exempt from public disclosure for a specific period. This confidentiality typically lasts until the investigation is concluded or until the time when the disciplinary action is finalized. The purpose is to protect the officer's reputation during an unproven accusation and to ensure the integrity of the investigation. However, once the investigation is complete and any disciplinary action is taken, much of this information often becomes public. B. Limitations on disclosure, 18.d.1.b on page 138. Even during the confidential period, there are limitations on who can see this information. It's usually limited to specific internal personnel, legal counsel, or those involved in the disciplinary process. The law carefully controls who has access during the confidential phase. The agency cannot just arbitrarily release it. C. Unauthorized disclosure penalties, 18.d.1.c on page 139. Given the importance of this confidentiality, there are penalties for unauthorized disclosure of these records. Anyone who knowingly and willfully discloses confidential information about a law enforcement or correctional officer's misconduct investigation before it becomes public can face legal consequences. This acts as a strong deterrent against leaks that could compromise investigations or unfairly harm an officer's reputation. This section highlights the careful balance the legislature attempts to strike, protecting an officer's privacy during an investigation while ultimately ensuring transparency regarding misconduct findings. This concludes our detailed exploration of litigation, personal, and the initial categories of personnel records under C. What records are covered? Taking us through page 139 of your manual. Thanks for listening. In our next episode, episode 17, We'll continue our deep dive into personnel records, specifically covering sections 18.E through 18.N.1.Q, including conditions for inspection, criminal history, and various lists of personal information for public officers and employees, taking us through page 148 of your manual. Until next time, remember, the truth dies in the dark, so let's leave the light on.